Yes.
One of the Bihara properties concerned, the
Two pro 8 minutes. On this.
sale can be confirmed when SEBI can be directed to transfer the money to the ABC account as given in page 5.
Right. Follow.
So then the ABC gets some money to distribute amongst
Correct.
the depositors. But the second thing is, as far as the sale of the other property is concerned, the Michela property, the sale was confirmed in favor of one Kartik. I'm sorry, brother, has been taken in favor of two people. One is Narayan Chandra De and one is Ganesh Agarwal, as in clause 2.1. The names are given. But once the sale was completed and the entire amount has been paid, there is another offer which has been received, which your lordship will find at clause 2.3 at page 5. It's a claim, it's an amount of 30 lakhs, which is more than the highest offer which has been received for the Mecheda property for that is 219.42. That was the earlier amount which was received. Do you leave it here, Dr. But direction may be fast for this person to deposit the entire money and the sale can be confirmed or as you lordship.
Behala property, there is no other offer.
There is no other offer, my lord.
280.
And then
Mecheda, there is another counter offer of 140 Patra.
yes.
Correct. And your prayer is with regard to about all the assets in the enforcement directorate ML case number 2 of 18 charges trimming the expedited so that that can be processed.
Lordship, this is actually under the rules. There is a restriction. Your Lordship, under the Prevention of Money Laundering Restoration of Property Rules 2016,
Charges have to be
framed. And this is where it is paused. Lordship, also if your Lordship takes once section 8(7) of the Act.
Yeah,
May I hand over one to Lordship? Section 8(7) relates to whether trial will not be conducted. If directions may be given. Sorry, my lord, that's my book. It's slightly marked. it was only written on 8/7 to the effect that the trial cannot be conducted for any other reason. If it can be brought under for any other
So
reason,
what is the other reason?
but here the depositor's money is
That is not the reason.
charge needs to
The
be
reason should be attributable and read in relation to the preceding instances of death or absconding. Might be if at the option of the accused, proceedings are stayed by a superior. We might read that as falling within the generic expression, any other reason, by relating them to the conduct of the act. If you see conduct or incident peculiar to the accused, stalls the proceeding, then subsection.
present circumstances. The charges could not be framed. There was a transfer proceedings. The proceedings were transferred to a different court, and thereafter a writ has been filed challenging that.
As we notice that writ petition is in our quality supposed to have been assigned to us.
I believe that petition number is
We will look into that. You followed your submission. Any other direction as of now you want?
Lordship, as far as Lordship, there is an amount which is being deposited from the hotels which are being run. A sum of rupees 5 lakhs is being deposited with the enforcement directorate. If those sums can also be directed to be given to the
Lakhs is
Lordship per month, 5 lakhs per month.
all right, let us see how much what is the corpus general.
The statements to disclose about 5 crores have been deposited till date with the you will find that at page 31 of the
No, your prayers in the page 25. Right?
yes, my lord. Prayers are in page 25.
May I crave for a copy of the report? I'm appearing for reserve time to pay their demand. In both item number 1 and item number
Mr. Vivek, with regard to the enforcement related, there is a large corpus now. What steps are you taking with regard to dispersal of that?
As per my instruction, an application was made by for the adjudicating of authority, and they had said that sale can be made of those that order initially. Yes, the
Has
the dispersal.
passed an order
Yes.
of attachment.
Yes,
Have these orders of attachment been used by India?
similar. They have not been applied. Initially, we had our reservation saying that these, until unless the adjudicating authority directs the committee to dispose of, we cannot.
These are not jurisdiction of authority. Because of the attachment, it goes within the ambit of the special court. Correct? Now, we, by exercise of our superintendent powers, can direct the special court to dispose of the assets in a manner which we propose. That the special court will pass appropriate orders. But first thing is, the attachments have been done. Is it within the ambit under the act to dispose of these assets or transferring these assets to the committee for disposal?
Well, as far as my instruction would be in one of those cases, my instruction comes.
You have got a copy of this report.
I suppose as of now, I don't have.
Let us do that. I put the pen for saving. You have got a copy of the report. Now with regard to the two properties, Meseda and Behala, what is your stance?
As far as the Kerala is concerned, it is already entire money has been appears from the report here. The entire money has been taken. But as the HLA is concerned, there is an application is pending.
So this
Now
is
the lordship
no
can decide.
Meseda, the proper the Behala money is deposited where?
With SEBI, why not?
To the city.
With
It is
SEBI.
lying with the city.
So what we do immediately is we confirm the sale so far as the Behala property is concerned and direct the transfer of that amount to the ATC for disbursal as per screen frame. Number one. Number two is with regard to the medical property. Please give a notice to Mr. Patru. Is he represented before us?
Yes, when an application has been filed, it has been signed.
Application is,
But we can file even notice to the next year.
please give a notice so that if Mr. Patru can, and also a notice to the successful bidder. So if Mr. Patru will deposit the advance, or the successful bidder can meet that amount, or put in an additional amount, we will immediately confirm the same. Mr. Banerjee, what do you say?
That's regular. I am appearing for both the deposit and I have an application.
Huh?
I have a separate application before my Lord Malord for sale of the properties.
Which say?
But that's for a can.
No. Do they relate to the Behala or Meseda?
No, master.
That thing will come later.
Yes. I'll make it.
What? You are not appearing for the company?
No, not in this matter.
Oh,
Not in this matter.
oh, sorry. I thought that you were appearing. Oh, you are appearing for the company in the NPS group, right? Sorry. You
No,
got it confused. Madam,
That's why I'm appealing for the company and let it start.
uh, what we are saying is it is to the benefit of the company that we get the best possible price, right? So let us give notice both to the successful bidder as well as to the applicant who's made a proposal for a higher amount and consider it on the next day. If the applicant is not before us, we dismiss his application saying that he's not pursuing the application and confirm this. Alternatively, we ask the successful bidder to match the applicant's price or put in a higher price, right? And Mr. What we propose to do, so far as these amounts are concerned, you please give a note on behalf of you as to how you propose to deal with this about 1,000 crores.
Saying whatever the attachment is.
Two things have to be seen. Whether the attachments have become final and binding. Till they have not become final and binding, I don't think they could be prudent to dispose of the assets. Secondly, to the extent it may be, let us say, out of 1,000 crores, 500 crores have become final. Then we can work out how this 500 crores in terms of the PMLA Act and rules can be dealt. One, the remainder subject matter of we will request you to expedite the appellate hearings. Auction 2.19 crore of Behala will be directed to be put into the till of the ADC, with the other notices to the applicant as well as the successful bidder to be considered on the next, right?
May I just add one thing? As far as the bidder who's put it the lower amount, they have deposited the entire amount, including 1%.
We have no
Which we-
difficulty, sir.
Let
What?
them also, the other person also let them deposit their.
First, let the other person be present before us. If he is present and we put him to conditions, if he is willing to accept the condition, then only the question of matching his amount arises. Theoretical quoting of price will not do. Show us the color of the money, we raise your hopes. Otherwise, no. Right? And Mr. Banerjee, you wish to purchase some.
No. I don't wish to purchase Malad. I am appearing for two of the depositors.
Right.
My CAN number is 12.
Right.
2020. Malad, I Malad want to Malad pray before Malad. I want to show certain orders of my Lord Malad, whereby Malad the hotels, which are like around 22 hotels, which are being run. Now the report even says it's been run by the last management directors. And they have been appointed and they are running the hotels. How is that possible under the law? And I want the sale of those hotels, by my Lord, or the ADC, and that
we will get ED. Which hotels have been attached by ED?
there are hotels, there have been
Please see.
I have given a list.
include in our report that also. Let us come on.
First, you examine when you come to Mr. Banerjee's application. You examine the prayers in his application in relation to attached properties by you. If they are not properties attached by you, your response is not really material. But if they are properties attached by you, we would require your response. So far as SEBI is concerned, we will nonetheless require the response of SEBI with respect of these properties. The thing is, one must now take a call on this. A, do we dispose of the hotels as going concerns, or do we permit the ADC, clarify our earlier question, and permit the ADC to run the hotels and use the profit or the returns from the hotel to liquidate the outstanding dues. This is a decision which has to be taken, hearing the agencies, the company, and naturally the depositors.
Only one issue what I have with regard to the running. Lordship says running, but if the running is done by the directors who were there in the board when the company did all these activities, therefore the whole function is
that is where we are trying to get a clarification from ED.
Well,
I tell you why. If you see the PMLA, once a provisional attachment order is passed, they may continue to possess the respondents or the persons against whom the order is passed would continue to possess and naturally use the assets.
Here, may I just say something?
Let us finish. Then you respond. The assets can continue to be held in their hands until and unless it is made final. Once the order of attachment becomes final, possession has to be. So we want to know from them what is the status of the hotels.
May I just say here something? I exactly thought that this would come from my lord. What has happened here? These assets were all under the ADC. The ADC has formed this management, wherein they have appointed the whole director.
Because the ADC has representative of the company also.
Yes, but not the erstwhile directors. Then the functioning of the ADC becomes a little questionable, because
we will see that if necessary, we will request the ADC to have independent persons overseeing the affairs of the company so that there is no siphoning away, etc. of funds.
And the manner in which the companies run or so.
Yes.
Lordship, I have filed CAN 14 where I have made an application for operation of these hotels.
Well, you.
I'm the intending party to enter into this application
No.
for operation of these hotels.
So who are you are a third party want to run the hotel? If let us say we will and there is some objection as given by a few depositors with regard to the question of we will have to put up the management of the hotel also. up for auction as to the person who is ready and willing and competent. We have to form a committee for the purpose of selecting an operating agency. You can't just give it on a person making of application like that, right? We'll consider it.
I am also quite aware of the additional only one in my application, one issue, since Lordship is directing them to check up my lord and come back. Only the first prayer where my lord I have to be added, otherwise my lordship will not be able to my lord consider an adjudicate. First prayer of my application will be granted.
We will consider.
Be added.
Report of
So far as
My application also be added, madam, let's say on behalf of some foreign fund authority.
foreign fund authority we will add.
Can 16 and 17, one for additional party and another for appropriate order.
That appropriate order we will ask parties to file it. And then we will.
only one thing about the in the litigation filed by the company and the former respondent, there's a decree in my favor passed by TRAI, upheld by the TDSAT and in the SFP has been dismissed. There's around 2 crores more due along with running interest. I'm only praying Lord, I can apply before the ADC or before your Lordship's court, obtain the reports of the ADC to find out what funds are there. Thereafter, I can come back before your Lordship and ask for release of some of the funds to satisfy the Lordship kindly grant me that release.
No, you are not a depositor.
No, my lord, I'm not. But there's a decree already there. And the funds have been attached by my lord TD.
Yes, we put into execution as per law.
It has been put into execution.
So,
And my lord, the writ petition, the company has filed a writ petition alleging that, my lord, because the ED has attached the bank accounts, they cannot pay us the funds. The funds are with the ADC. If your lordship considers, my lord, whether it will be some amount in any way, my lord, I'm not a depositor, but it is with regards to running of the company while we have aired certain programs through our satellite channel. My lord.
one thing.
Scope, I understand.
We need a scope. Secondly, do you have a priority of charge?
That I have,
We
that your
understand,
lordship,
we understand statutory, like corporate priority of charge.
yes,
Bank, where there is a charge created or a sufficient security interest registered. They will definitely have priority of charge.
yes,
Statutory dues, priority of charges. ED,
priority.
attachment priority. But
In the list
for
of unsecured
as
creditors,
a
maybe I have
person
some.
who is a
Slightly
degree holder, please advise us to what extent
If
we
it
have a
is a
priority of charges over, let us say, Mr. Chakraborty and Mr. Banerjee's clients, who are sundry creditors.
Yes, I am also in that line.
That is, we consider
That is all that I'm
in
saying.
the scheme it will be considered.
I am appearing in connection with this
I
matter.
would Lordship kindly just grant me that if your Lordship so deems fit to obtain copies of the reports of the EDC. Otherwise, I cannot.
I am appearing in this matter for my reference submitted for in WP number 18257. The only thing I want to indicate to your lordship is that our case before your lordship is that there is a certain amount which came to our account by way of an arbitrational award.
Oh,
Now that amount has also been seized by the
it's a Gupta, the definition of proceeds of crime is too wide. Even innocuous funds, which may be equivalent to the value of the amount which have come into your hands as tainted money, can be attached in lieu of tainted.
Smile. I bow down to your lordship. Provided it has come to my hand in lieu of tainted money. But in
You don't refer, you don't, it is something like this. ED shows money trail from the criminal activity or the predicate crime into your hands, which is over 20 crores. But the money trail is not traceable. However, you have a property of 15 crores, which is independently purchased. In our reading of the definition of proceeds of crime, the value of that property can be utilized against the quantum of proceeds which ED can prove to have been traced into your hands. So if the arbitral award is X amount and Y is the amount which ED through evidence shows has flown into your amount, Y out of X, if X is larger, can be brought out from the value of the arbitral amount.
My lord,
That is the law. You might say it is quite a draconian one, but that is how the law is worked.
my lord, on the 26th of September, your lordships had ordered that in view of this situation, you directed the respondent authorities.
In fact, we have in a particular case what has happened is there was about just about 2 lakhs. 20-30 lakhs was flown into an account of someone. And there is a immovable property which is purchased. At the time when he purchased it, the property was about in new town about 13 lakhs. Now it has become 2 crores. So he is saying that why should it be attached to 2 crores? If it's the corresponding value, then the value that the amount which ED shows have been flown into my account for the purpose of negotiation, etc. You take it out, you can't keep a property of 3 crores attached because you show 30 lakhs would flown into my account, because that 3 crores is not proceeds of crime in the classical sense. There is no money flowed to that amount. But what you are doing is you are using the definition of or value thereof and saying that we are attaching it against that 30 lakhs which we find flowing into your account. That we have decided to adjudicate upon exchange of affidavits. Restrain ED from further action.
But this is where I join issues. My lord, on 26 September, lordship has directed this that let affidavit in opposition be filed by the respondent within 2 weeks after puja vacation, if any, and reply to 1 week. That affidavit has not come.
Already let them file the
That is all I am praying.
all that.
That is all I am praying.
That is in document number 185. So only one submission I have.
Yes, yes.
Only one submission I have. But in the last occasion, on 21st of 11/2024, your lordship directed in paragraph 7 that ADC is directed, is requested to assess because the registered item circuit page for unknown property. It was the past property, but it has now been totally the land permission.
Prayers of ADC as of now does not incorporate that. Where we will look into it. That order is already there.
Another submission is there. Just now your lordship said. Now the auction which are being placed, which are being in the also in the 30th of December, some properties are. All these properties are at us complete. ED has granted permission on the basis of the minutes of the meeting. It was recorded in the minutes of the. So on the basis of that, the ED has granted permission to auction the property and the sale proceed to be transferred to the ADC due to the fund. That is the minutes made by the ADC. I don't know whether my learned friend is appearing for the ADC. It is well settled minute between the ADC and the ED that the property can be sold. Now, your lordship, since your lordship has directed learned friend to take instruction, I have no objection. But that point has already been taken care of.
That's your submission. We will note. Report. We have followed your submission. We pass orders on you.
May I take note, my lords?
Yes, your junior is there?
Yes.
Yes, anything else? 10th interim report is filed by the ADC. We have perused the report. In respect of prayer regarding auction of Behala property on 25/11/2024 by we confirm the sale of the property described as described in serial number 3, bracketing hereinafter referred to as Behala property, in the auction notice issued by SEBI in favor of Narayan Chandra Dey and Ganesh Agarwal for rupees 9 crore, 2 crore 19 lakhs 42,000. The amount, SEBI shall credit the amount.
It should be, that's 2 crores 1862, and it was sold to PV Construction.
Oh, sorry, 2 crore, 2 crore 18 lakhs 62, page 4, 2.1, two Messrs PV family. We confirm the same, right?
Saving from credit.
The amount to the account of the ABC. In respect of the auction of property described in serial number 5 of the auction notice, we note the successful bidders, notice bracketing hereinafter mention the property. The successful bidders, Narayan Chandra Dey and Ganesh Agarwal, have already deposited the bid amount to the tune of 2 crore 19 lakh 42,000, along with % poundage fee. Footstep. However, another applicant, one Kartik Patru has applied before this court, offering a sum of rupees 2.30 crore for the said property. Issue notice upon said Kartik Patru as well as the successful bidders. No, it has taken out an application. However, Kartik Patru is unrepresented today. Notice be issued upon who will give notice? You will give notice. Appellant shall issue notice upon it is a requisition, it is an appeal. There was an appeal by the company also, or the
Appeal is for the NPS.
appeal was affirmed. Repetitioners shall issue notice upon Mr. Patru as well as the successful bidders to appear before this court on the adjourned date, that is so and so. In the event Mr. Patru fails to appear on that day, his application shall be dismissed as his application shall be dismissed and the same shall be confirmed in favor of the successful bidders. ADC has also referred to properties attached by ED in ML 08 ML09/2024. Deputy Solicitor General, you are representing ED also, Mr.
I'm representing ED also.
The Deputy Solicitor General seeks time to take instructions in the matter. He shall submit report with regard to, in respect of the stage of the criminal proceeding and also in the stage of the criminal proceeding, and also indicate the manner in which the attached properties may be Mr. Ray, you were referring to which rule?
But if the rule has been marked with a yellow flag,
No,
it's under the rules. 2016 rules.
Hmm?
Should be under the 2016 rules.
2016, yes. Okay, what?
3A.
Rule 3, 2016,
3A,
3.
3A, 3A.
Manner discrimination. After charges are paid.
Yes, because sir,
Yes.
what was happening, what you just pointed out, 8-7 is only with regard to confiscation. The disposal for release for payment is under 8-8. But 8-8 only speaks of confiscation when property is confiscated. 3A gives an independent power in the rulemaking provision and says that even prior to confiscation, 3A can be utilized.
On the basis of that, 19 crores have been transferred. That's a success in respect of land.
So there still charges have not been.
And over another copy, finally managed to get it.
Shall
And also indicate the manner in which the attached property may be
maybe restored or utilized to pay the depositors. To depositors / claimants. Good stuff. All right, Mr. Trivedi, you indicate to us how much, etc., where the charges, if charges have not been framed, then we direct the special code or whatever is there, we proceed with that. Yeah. Report has also report with regard to the audit reports of so and so and so and so have also been placed on records.
PVCL.
Has been placed on record.
We were seeking an extension to file for chocolate hotels also.
PVCL you have filed. Audit report of PVCL is placed on record.
That report of BBCL can be verified by the CB if possible. Because but if they are not
Adding, you go through the report. report of PBCL is kept on record. Further, audit report of CHCL,
CHPL, my lord.
CHPL
We have still 3 months time to submit that report.
be filed as early as possible. All right.
That's one more direction we would require.
SEBI is directed to look into the audit report of BVCL, and submit its responses for judgment. I think so far as interim report, this is enough.
Lordship, one more direction. Lordship, the EDC needs to be reconstituted. Your Lordship will find that at page 24. The nominee of the state government around there.
Who is appearing for state government?
Which is right.
He's not physically present or virtually present. Nobody is present.
Your Lordship, it might be internal page 24. Somebody else has joined the ADC as the state representative. Accordingly, the ADC may be reconstituted.
The ADC is reconstituted. The state representative of the state of West Bengal has changed. ADC be reconstituted accordingly. Now, with regard to 1 second.
So far, my lord, can application 17 of 2024, an application for addition of party on behalf of the Provident Fund Authority.
Can 17 of 2020.
My lord, and also my lord, Lordship, and also my lord, I should show my lord.
Please file your opposition.
But that Lordship, my lord, I have also filed an application for appropriate orders, and 16 of 2020.
The lordship of company is the copy of the.
We are directing service of copies on all appearing files.
Well, I have served upon all the respondents.
Correct, serve it again.
And everything is certified to take.
Correct. So what we will do? We dismiss your applications.
Sorry, my lord.
No. So if you feel that you will not serve, we will also not pass orders. So 16 and 17 of 2024 in কোন WP টা আছে সেটা দেখুন।
WPA 27005 of 2016.
Copies of the applications be served upon the appearing parties, particularly the company, SEBI, Enforcement Directorate, and the writ petition.
I'm getting.
All right.
I shall.
Right.
Can 14, so the copy and reject.
We will reject your application, madam. That's why we are keeping you last.
With regard to calculus, which Mr. Banerjee has placed.
That will come, sir. As per priority. Full stop. Opposition, if everything opposition failed, we filed within 2 weeks. Reply 1 week thereafter. So far as your provident fund is concerned. Now, for Mr. Banerjee, sir, applicants, what is CAN?
Calculus bank.
CAN 12 of 2024. Applicants are depositors. They may be added as parties to the proceeding. Writ petitioner shall make necessary amendments to the writ petition and add the applicants as added respondents. Anything more?
My lord, with regard to the list of hotels, my lord has directed ED to pass some response to that.
All right, we'll see that later on, not necessarily.
Before, item number 2.1.3, page 25. Dividing their money, which is lying in the ED, that is stated in paragraph 6, where 5 or something, it is transferred to the EDC.
There's no hurry as of now, 2 crore odd is going to issue. Then we will again talk with release response They are cooperating with the agency and with this court. So we will factor in. Don't rush things, because if you, what will happen is then the company and any other accused will come up and say that this was done without proper procedure followed. Let us follow the procedure and go ahead with the process.
My understanding, what I'm calling from my lord, that 3 is the rule, my lord. It is 8 proviso also, my lord, is proviso.
Yes, 8 proviso is clarified in
Yes,
3.
3.
That amendment was made because what was happening is till confiscation,
Yes.
which only upon conviction the assets could not be given to payments. So that interim arrangement, but the interim arrangement is only after filling of charge,
Yes, that is
as the agency has rightly indicated. So what we need to do is use superintendent's powers, ensure the filling of charge, and then go ahead with the
I'm great.
right. Now, Mr. Gupta's writ petition.
WPA 18257.
Mr. Ghosh and others file affidavits.
I will.
All right.
WPA 18257 of 2023.
And your can will be in relation to
In
this.
connection with this rate, my lord, I'm only praying for the leave. Can't find it.
Oh, you have not filed any can. So now what you do?
The only thing,
Mr. Ghosh.
yes,
In this writ petition, it said when you file the response, you make that.
very well.
That will be a combined. Don't
Very-
increase pleadings.
Very well.
In the opposition itself, you indicate that you would like the decree to be executed or satisfied through the ADs. Then we will get the response.
Lordship, lordship. Only one of time praying that leave with regards
Company is also there. Company file your opposition. Because relevant parties in this writ petition are the company and the decree holder. So affidavit of opposition will positively filed within 2 weeks, reply 1 week here. The directions are present.
Lordship.
Uh,
My lord, the direction on the ADC to furnish copies of the report if I write to them.
ADC shall also furnish copies of the interim reports to the parties.
And the enforcement department will also file a.
Mr. Trivedi, in this matter also you are a party because this is an attached property.
Lordship.
The problem is they have a particular asset which they say is naturally unpaid because it is a habitual outlet. You have attached that outlet. They have challenged the other, saying that it will be without choice. Now our understanding is deeply. At this prime side, that is why we have not passed any Indian. The reason being, it is value against the tainted money which had flown into the company. Be that as it may, there is an applicant who wants his decree to be satisfied on that. If it is attached, the decree holder cannot override the attachment of the under PMLA. So please file your appeal. We will dispose of that.
No, can be served,
Can is not there. Repetition is there. I think the junior has the repetition because Madam appeared in that.
Yes, my lord.
So please file your response or appeal to the.
Yes, my lord. We have.
It's a small issue.
Yes, my lord.
We just dispose it of so that if let us say find out what is the quantum of proceeds of crime that you trace to Mr. Gupta's client's hands. What we understand, one interpretation, Mr. Trivedi, we need to. When you attach proceeds of crime where the money trail is clearly established, there is no difference. But if you attach, let us say, the amount which has flown into the hands of one of the accused in PMLA is 3 crores. And that is a part of a larger corpus of 30 crores. Can you attach the entire 30 crores? Or you have to attach only that portion which is the proceeds. This is a legal submission we would like you to make before us. Right?
Noted.
So that we will keep for hearing as soon as it is ready. We will dispose.
Grateful.
And Now, madam, your application, can 14. You want to run the hotel.
Yes, and also I'm willing to purchase if.
So we keep your application in abeyance now. We don't pass any orders. What we propose to do, hearing Mr. This application of yours will be heard with Mr. Banerjee, sir. So we will say can so and so shall be heard with can
12, my lord.
can 12. If we pass orders that we feel that the management should not be run in the manner, or the management of the company should also be auctioned, or offers should be opted from intending companies or promoters who would like to run the companies, then we will take the responses of petitioner, ED, SEBI, and then pass appropriate orders to guide the ADC in the manner of running the companies. One. At that stage, we will also pass orders in your application, permitting you to participate. But if we feel that the way EDC is running as of now is good enough, we will not pass in orders.
We did serve the copy to
And you give copies to it. Copies be served, can shall be heard around. All right.
I have also filed that can 15 my lord with the same period. Yes, I'm sorry.
All cans like that will come up. All setup cans will come up with the setup deposit.
Hearing में देखता तो स्वयं सो बोले देखता स्वयं सो
But it needs to be done at this point of time. Next date when?
May I bring it to your lordship's notice one, for instance, by your lordship's earlier order in November, 21st November 2024, there is writ proceedings which have been initiated before this court challenging the transfer of the
Yes, that was supposed to be assigned to us.
Yes, my lord.
Till now it has been assigned or not, he will tell us. Right? We cannot assign ourselves, can we?
That's for the ED to.
ED or repetitioner if they will not partner. So what? You can always ask for the assignment. We will pass a take power order and write a letter.
Because in the last of
Enforcement Director,
the ED
Mr. Deputy Solicitor General, there was an earlier direction. The repetition which is standing in the way of framing of charge. We had observed that it would be appropriate if it is assigned to this. If you could take steps for us.
What happened? Single judge, release. Then will not it is for the petitioner who pray for assignment that will not lead you.
For permission. You are a party, isn't it? You are entitled to ask for this. You are entitled to ask for it.
Why not I?
What? Because this is standing in the way of dispersal of funds.
But should the other prayers may be considered subsequently to the other
Definitely. When do we keep these matters?
With regard to the other property where Malad has directed the petitioner to serve, that should be taken up because otherwise that one place will be kept lying and this pending application will be there, nothing will happen with that fund.
So what is that other property?
That is, I think, can 13 has been served upon everybody regarding that Mecheda property.
Mecheda property.
That
আচ্ছা
should be taken
Mecheda
up
property
on
শোনো Mecheda property যেটা can আছে না ওই কার্তিক পাত্র, let us keep that matter on 14th of February.
Yes.
আচ্ছা আমাদের কি
Malad has saved that Proag matter. 14th of February.
Oh, sorry, 14th is Friday, right?
Friday.
Oh, 13th we have kept prior.
Right.
So
Can it be before that?
no, we can't.
then will 13th is the
We will keep it on 20th.
20th.
We keep this on 20th.
20th.
All matters of Rose Valley come up on 20th.
20th.
Prayer will take up on 30th. Rose Valley we will take up on 20. All right.
Great.
Other matters.
May I take back the
Item 11 and
Not this, not today. 30. Next, 12. Well,
Item number 12, my lord, as per the picture, Lord, our instruction was to apply on behalf of the private respondents from 1820. Before I speak, in one thing, this matter was filed to two-line page. This matter, when it was taken up, it was supplemented by this scheme that it's a policy right.
matter relates to SEBI. SEBI given report.
Is this particular matter?
In this matter. SEBI shall submit report whether the affairs of the company fall. SEBI shall submit report whether affairs of the company fall constitute illegal money circulation scheme or any other scheme within its ambit, within its area of investment.
So already SEBI, the appropriate authority under SEBI, the full-time member has passed the order restricting the company under this.
Okay.
SEBI.
Oh, then it is not necessary.
So these are there. Already I have already annexed all these orders. Roshi, kindly come to page number 230.
One is for the company.
From 19 to 21, I will represent the company.
You are for the companies. All right, all the respondents filed affidavits. Affidavits in opposition we filed within 4 weeks. Reply 2 weeks. Matter will appear in the monthly list of March 2004. Monthly list of yes, it is. Also, Mr. Brand, because if SEBI has already passed an order, that area is covered. It admits that it is within the scope of its inquiry. Respondent companies, private respondent numbers for the company.
19, 20, 19, 20.
Hey, respondent company, who are they?
Respondent number. I'm from 19, 20, 21.
Shall not dispose of the properties, shall not dispose of the property, the assets of the companies without the leave of this court. We cannot sell anything without the leave. SEBI shall be made, petitioners are directed to amend the statute of the, we have considered the allegation, we have considered the above-ments in the writ petition, including the prayers. Writ petitioner alleges that the respondent numbers 18 to 21 have been carrying on illegal money circulation business. SEBI has passed orders restraining the company from inviting deposits from the public. In such view of the matter, we consider SEBI as a necessary party and direct the writ petitioners to add SEBI as a party respondent. Necessary amendment to the writ petition will be carried out in the course of the week. Copy of the petition we served upon Mr. Banerjee and Mr. Doctor, learned counsel representing SEBI. Full stop. Until further orders, respondent company Respond number 18 to 21. Their main officers, agents shall not dispose of the assets of the company.
Respondent who is not here.
This was passed by member of the Settlement Fund Committee under MCSGC Committee against NS, that is, has been appealed to the National Stock Exchange. There is a note passed by that. They also passed that directing that is under SEBI.
Who is the authority to stop this?
But that it is under the NAC, page 231.
NAC, what is
National Stock Exchange, National Member and Post Settlement Guarantee Fund Committee of the National Stock Exchange.
Okay. ওইখানে সেবি বলেছি তো National Stock Exchange had restrained the company from inviting deposits from the members of the company. In view, in such view of the matter, we consider SEBI to be a legitimate.
The membership was expelled. That is the order.
Okay. Let them not dispose of assets without the legal. It cannot.